Well, welcome everyone to this, the second webinar in the current series on Europe's new crypto asset law, MiCA, the Markets in Crypto Asset Regulation. MiCA has been a very long time in coming. Back in 2014, the first report by an EU institution was published, setting out the risks and harms of what we then all called virtual currencies. Let's face it, at that time, there was probably only Bitcoin and a handful of other alternate altcoins. Some of you may have read the first MiCA explainer, which we published a day or two after the European Commission released its proposed MiCA text as part of the EU's digital finance package, way back in, well, 2.5 years ago nearly, September 2020, which we then followed with our first series of MiCA webinars. The final English text of MiCA was approved by the European Parliament and the Council of the EU, that's effectively the member states, the countries of the European Union, back in last autumn, and it's now being translated into the EU's other 23 official languages. All 24 language versions have to be equally authoritative. So it's no mean task to translate 400 pages of sometimes technically complex legal text that will apply across all 27 member states, as well as the 3 additional EEA countries. Now, MiCA will be directly applicable across all 30 countries without needing to be further transposed into national law. Last month, we updated our concise, detailed MiCA explainer, and 2 weeks ago, we held the first webinar in this series, which included an overview of what MiCA covers and who will be caught by the new law. The updated explainer and the previous webinars can all be found on our website, www.xreg.consulting. And of course, you can drop us a message in the chat or by email or by filling in the inquiry form on our website, and we will happily send you copies and links. MiCA principally covers issuers of all kinds of tokens, as well as CASPs, crypto asset service providers, and it even includes requirements for some other financial institutions, such as banks, when they engage with crypto assets. MiCA, the 400-page regulation itself, is, however, only part of the story. In fact, it's just the beginning. MiCA provides for a total of 38 so-called level 2 measures, such as binding, implementing technical standards and regulatory technical standards, and non-binding but equally relevant guidelines. And many of those caught by MiCA will also be subject to other EU legislation, such as the Digital Operational Resilience Act, DORA. Some will also be caught by the EU's e-money directive and payment services directive. Overall, we expect anyone within scope of MiCA will need to comply not just with its 400 pages, but thousands of pages of EU legislation, delegated acts, technical standards and guidelines. We'll be covering these in more detail in the next series of our MiCA webinars. MiCA is likely to come into force in the second quarter of this year, and it will become operative at various stages during 2024. Publication of the technical standards and guidelines, which are the primary subject of this webinar, are not always well aligned with the statutory timeline. So we're in for a couple of years of fairly intense activity. The MiCA journey, frankly, is barely underway. So today we've set out to explain MiCA's impending 38 technical standards and guidelines and give a flavour of what is to follow, including future reports that will inform the next iteration, perhaps MiCA 2, and how, for example, DeFi and NFTs are likely to be regulated. But first, some housekeeping matters. This webinar will take an hour overall. There'll be around 10 minutes for question and answers at the end, so please put your questions in the Q&A box. You can do that by clicking the Q&A button, usually found at the bottom of the Zoom window. We'll finish on the hour, but today's speakers will stay on the line, if that's still an appropriate expression, for a little while afterwards, in case there's anything members of the audience would like to discuss with us regarding either today's session or indeed anything else about MiCA. Before I introduce your speakers, let me just say a few words about XReg Consulting. Now, we're a boutique public policy and regulatory affairs consultancy. We just specialize in crypto assets. And now we are around 25 folks, a little over 25 folks. Nearly all are former regulators or government policy officials. And we operate from some 6 locations around the world. Now, we help folks in the private sector, so crypto asset businesses, by helping them understand the regulatory environment and what the rules say, but also helping them to make their choice of jurisdictions where they want to operate from that best suit their business models. We also help governments in formulating sound policy and crafting their legislation and regulation. We help regulators and other public authorities understand what crypto is about so that they can be more effective in their regulation. We help them by building capacity. Now, my name's Sean Jones. I'm a partner at XReg Consulting. I'm a former regulator. I'm joined today by Lloyd, who's a former long-standing senior government law officer and also XReg's EU policy lead, and David, who, like me, is a former regulator and one of XReg's consultants specializing in MiCA. Now, David and Lloyd will take you through the 38 technical standards and guidelines. We'll stop by 4 of them, which we think are particularly noteworthy, just to give you a flavor of some into some more depth on those 4. And we'll also give you a sense of the timeline and the next steps on the MiCA journey. And then we'll finish off with the Q&A session that I talked about earlier. So without more ado, let me turn over to David. You have the floor, David, all yours.
Thank you, Sean. Let me start by saying that there's a lot on this slide to take in. I'll be going into more detail on each of these separately, but before that, just a few points to note. The process of drafting the guidelines and standards by the supervisory authorities in Europe will begin in the coming months. These will be drafted for both issuers of stablecoins or other tokens and for crypto asset service providers. Here you'll see an overview of the standards and guidelines for stablecoin issuers and the distinction between what will apply to issuers of asset reference tokens and to issuers of e-money tokens. Standards here in red will be binding, and guidelines, which you'll see in orange, are non-binding. As you can see, the bulk of these are technical standards that will apply mostly to issuers of asset reference tokens or to both. The majority are set to be submitted to the European Commission for approval and adoption by 12 months of the date MiCA comes into force. It's important to note that while there are a number of areas that are unique to the crypto asset industry, There are also a number of areas that will be borrowed from or based on guidelines or standards that are already in force for other financial industries. This includes areas such as complaints handling, conflicts of interest, governance arrangements, and market abuse. We're in touch with the European supervisory authorities, and we'll be monitoring how these develop, including through the consultation process that I'll get to a little later. So before we go into further analysis of a few of these, let's run through what is set to be drafted for issuers of asset reference tokens. So the European supervisory authorities will draft regulatory standards on the liquidity requirements for an issuer's reserves. These will have to take into account the size and complexity of the issuer's reserve assets and the asset reference token itself. I'll be going into more detail on this standard a little later. There'll also be standards detailing the investments that will be permitted for an issuer's reserve assets. This will specify which financial instruments can be considered highly liquid with minimal credit risk and therefore suitable for investment of reserves. There'll also be standards specifying the methodology to be used to estimate the average number and value of transactions per day. This will be for transactions of asset reference tokens that are used as a means of exchange. Then we have standards on areas such as complaints handling, own fund requirements, conflicts of interest, and some procedural standards around authorization and disclosure. We have guidelines on governance arrangements, which will include specifics on risk monitoring tools, business continuity, and independent audits. There'll also be guidelines issued on the suitability of shareholders and the management body. The standards and guidelines we've noted already need to be submitted to the European Commission for adoption 12 months after MiCA comes into force. There are also standards that can be submitted at a later date. So this includes a standard on additional obligations for asset reference tokens classified as significant. Asset reference tokens that meet at least 3 of several conditions set out in MiCA will be classed as significant. Some of these are quantitative. So, for example, the number of token holders totaling over 10 million individuals, or a market capitalization or size of reserves higher than 5 billion. Other conditions are more qualitative. So this includes considering the interconnectedness of the asset reference token with the financial system, or the significance of activities of the issuer on an international scale. It is these qualitative conditions that the standard will aim to provide further details on. MiCA notes that the European Commission will be empowered to adopt a delegated act on this. The Commission has 36 months after MiCA enters into force to adopt this delegated act. And this may prove to be a little late, given MiCA's implementation date for issuers of stablecoins is only 12 months after the publication of MiCA. But the European Commission is already ahead on this one, having already made a request to the EBA for technical advice on this standard in January. So the process is already underway. There are other standards, so the format and content of the recovery and redemption plans required for authorization. Dates for the submissions of these standards have not been specified in MiCA just yet. There will be guidelines drafted on when the transfer of e-money tokens can amount to a payment service under the EU Payment Services Directive. These guidelines will detail the characteristics that would bring transfers of e-money tokens within the scope of this Payment Services Directive and therefore require an additional authorization. These guidelines are intended to help crypto asset service providers understand whether the transfer service they provide for e-money tokens will fall under this scope. If so, they'll have to ensure that they either seek the necessary authorization on top of the MiCA authorization that they already have, or that an authorized payment services entity is providing this service on their behalf. For both asset reference tokens and e-money token issuers, there will be some less exciting procedural standards drafted, like the format of a white paper and authorization forms or templates, but there'll also be a standard requiring issuers to publish details on the environmental impact of their tokens, specifically the consensus mechanism used. This is a new area for European regulators, and we can expect to see more of this climate-related legislation in future across financial services. For now, though, this is unique to MiCA, primarily because of the publicity around Bitcoin and its environmental impact. We'll go into detail on this one a little later. There'll also be guidelines on when crypto will be classified as financial instruments. Again, something we're going to look in at more detail today. For issuers of tokens that aren't stablecoins, there are standards and guidelines on similar areas. So here again, you'll see standards on the format of a white paper and the environmental impact of a token, as well as guidelines on when crypto will be classified as a financial instrument. By virtue of being an issuer, or a CASP for that matter, additional legislation will also need to be followed. As well as MiCA, issuers and CASPs will need to comply with DORA, the EU's Digital Operational Resilience Act, which Sean already mentioned. This act aims to protect the resilience of financial services in the EU in the area of IT security. With this in mind, ESMA will be drafting guidelines on the standards to be maintained regarding an issuer's systems and security access protocols. This is very likely to be tied to DORA, covering IT risk management, incident reporting, and resilience testing, amongst other areas. While this guideline has been specified for issuers of other tokens in MiCA, asset reference token issuers are not off the hook for this one either. If you attended our last webinar, you'll know that DORA will also apply to issuers of asset reference tokens. I'm going to hand over to Lloyd now, who will talk about the standards and guidelines we're set to see for crypto asset service providers.
Thanks very much, David, and thanks, Sean, as well. Hi, everyone. Good to be with you again. As David said, I'm going to focus on crypto asset service providers, CASPs. I think many of you will already know from webinar 1 that a CASP normally needs to be authorized under MiCA in order to provide services to clients. But maybe let's just briefly remind ourselves about the services covered by MiCA. Custody, which is safekeeping or control of crypto assets belonging to third parties. Operating a trading platform, so if you operate a system to facilitate the buying and selling of crypto assets by third parties. Exchanging crypto assets for fiat or other crypto assets, or indeed both, and transferring crypto assets from one blockchain address to another. There are other services covered by MiCA that probably aren't a big part of the market right now, but to complete the list, let's just mention them. Things like brokerage services, placing or marketing, and portfolio management and advice. So over to the next slide. David's mentioned there's a whole raft of standards and guidelines. There are some standards and guidelines that apply to all CASPs. For example, on conflicts of interest, you'll be aware, or you may be aware, that there's a fundamental obligation on a CASP and on its management body to avoid conflicts of interest. And I think in a CASP context, this is typically going to arise when the management body becomes unreliable to its clients because of a clash between self-interest, the gains the management itself could make on the one hand, and the professional duties it owes towards its clients on the other. And the management body always needs to put client interests first. So if, for example, this is a fairly basic example, I think, the chief executive of a CASP wants to hire a relative without IT qualifications or experience to run critical IT infrastructure, which, as David and Sean have already mentioned, is an important part of the requirements, then they're putting their own family's interests above the CASP and its clients. And look, there are other examples out there. We've seen allegations in the crypto services industry in recent months of a crypto exchange business having used client funds to pay back the lenders of a separate business owned by that exchange. So the allegation is they sacrificed their clients' own funds to save an affiliated business that effectively couldn't pay its debts. So what the standards are going to do is specify the rules that a CASP needs to put in place to identify, prevent, and if it can't prevent, then manage and disclose those conflicts of interest. And, it'll probably include things like compelling members of the management body to disclose if they're likely to make a financial gain at the expense of a client. And disclosure there could mean disclosure to the client, or more generally to all clients and the public at large on the CASP's own website. So quite significant. Service continuity and records. As a CASP, you need to have in place a business continuity plan, effectively a system or a strategy for potential threats like natural disasters or cyber attacks. to ensure continuity of service to clients. That plan, crucially, has to include a strategy on information and communications technology, ICT, continuity. And that's to deal with interruptions to service, but a CASP also needs to have a disaster recovery plan. So also with an ICT element, by the way. So if systems and procedures collapse completely, a disaster, the disaster in the term disaster recovery plan, then data can be recovered and functions and services can resume through backup systems. So it's all about how you get back up and running as quickly as possible to serve your clients and protect their data and records. What we're likely to see set out in the standard is a requirement that the business continuity and recovery plans state how the plans were developed, who approved them, and how they're integrated into the overall corporate governance of the CASP. I think we're also likely to see a requirement for a CASP to have a preferred strategy, a preferred plan, a kind of plan A, and then to lay out various other possible strategies or plans to achieve its continuity and disaster recovery objectives. For good record keeping, what we're likely to see are measures for making archived information clear, precise, and complete. And that's so that the supervisory authorities can do their job, monitoring and enforcing the terms of MiCA. And more specifically, for example, that could mean requiring the full identities of all the parties to a transaction and that they're recorded on a reliable medium, or that the settlement currencies or crypto assets of a transaction are also accurately recorded. Moving down to complaint handling, there will be, I guess, when it comes into force, an obligation on CASPs to have an effective and transparent procedure for what MiCA terms the prompt, fair, and consistent handling of client complaints. But for example, I mean, there are some lacunae here, so there's some gaps. MiCA doesn't set a time frame within which a CASP needs to process a client complaint, and this time frame or deadline, if you will, we expect to come out in the standard. We also expect to see the procedures and steps a CASP would need to follow in processing a complaint. So will there be an appeal if the complaint isn't sustained, for example, and who should hear that appeal? And by the way, MiCA forbids CASPs from charging a fee for processing a complaint. So that's in case you're tempted to charge for one so as to discourage complaints from clients. Moving on to adverse environmental impact, which David has touched upon. It's a hugely important area across the EU, and this is no exception. MiCA imposes an obligation on CASPs to publish on their website information about the terms of the adverse environmental effects of the consensus mechanism, for example, proof of work, used for each crypto asset in relation to which the CASP provides services, so each of them. I think what we can expect here is that the ESAs, the European Supervisory Authorities, will publish standards that lay out exactly what environmental information needs to be published and how prominently it needs to be displayed on the CASP website. How aggregated or disaggregated that information and data can be, bearing in mind that in developing the standards, the ESAs will be looking at things like greenhouse gas emissions and figures around that. Authorization application. So the information you need to disclose to a national competent authority to be authorized as a CASP is already addressed in MiCA in some detail. That's in Article 54 if you're interested. And in my view, that information can be divided up into formal official information. So things like your legal name or the legal name of your entity, whether you're a company or a foundation or whatever else, not unimportant, but formal stuff that needs to be put on there, but also more substantive information like the CASP's program of operations, and also proof that the members of the management body are of good repute and have the right mix of knowledge, skills, and experience. So what the standard will probably do is specify in more detail the information that the application needs to contain. So for example, we might expect for good repute that the ESAs will, the supervisory authorities will clarify whether a self-declaration as to the background of the individuals involved on the management body will suffice, or whether they'll need external references or an extract from judicial records from their home country, or things like the specific skills or minimum years and type of experience that would be expected of a member of a management body. And no surprise, David's already mentioned this. There's some kind of boring but useful forms and templates that will be published. You don't need to worry about them. Just make sure you can access them and fill them in when the time comes. couple of guidelines, again, that apply to all CASPs. One has to do with reverse solicitation, the first one, and that's essentially for this context when a client located inside the EU seeks out the services of a provider outside the EU. And in that situation, the service provider doesn't have to be authorized under MiCA. It's an exception to being authorized, but you do need to be careful. And I'll park that there for now because we'll discuss that in a couple of minutes when we get to the 4 notable guidelines. Okay, another guideline, second one, is management suitability. So as part of the authorization process, there's an obligation for a national regulator to assess, again, the stuff I mentioned already briefly, the good repute, skills, experience and qualifications of all the individual members of the management body who will be running the CASP. There's also, I think rather strikingly, an overall assessment that the national regulator needs to make about whether the management body as a whole could pose a threat to the effective and sound management of the business, to the interests of the client, or indeed to the integrity of the market. So what the guidelines will do is spell out how the regulators should approach their assessment, similar to what we might see in the standard. And in fact, there may be some overlap with the standard I just mentioned. Things like, what counts as good repute? Will a self-declaration be enough? What are the risk factors that could lead a regulator to consider that the management body could pose a threat to the integrity of the market? All those sorts of things. And by the way, the guidelines will address similar points, not only for the management body, but also for individuals with qualifying holdings, which depending on the context can mean people with a 20, 30, or 50% stake. Okay, let's move on to specific CASP services on the next slide. There are a number of additional standards and guidelines that will be adopted in connection with CASPs. I'll say that properly, CASPs, that provide specific services. So if you're operating a trading platform, operating a system, in other words, that brings together buyers and sellers of crypto assets or other crypto assets or fiat, then there are some pre and post-trade transparency requirements that will apply to you. The standard will set out, we think, the content and format of the CASP's order book, client due diligence requirements, transparency over fees, when a CASP might suspend the trading of a crypto asset, and things like the price, volume, and time of transactions. Be aware as well that the content and format of order books relates to a requirement to keep them for a minimum of 5 years for all orders, or to give the regulator access to your systems, the CASP systems, so that they can directly monitor trades. On crypto asset transfer services, if you transfer crypto assets on behalf of third parties, so from one blockchain address to another, you'll need to have a legally binding agreement with your clients that must include, and this is at minimum, a description of the security system used by the CASP, what the CASP will charge the client for its services, and the law applicable to the agreement. The guidelines, we'd think, will probably add to those list of client rights, for example, on a client's rights to terminate an agreement early. So we can anticipate those changes. Quick word on portfolio management and advice. You will be a CASP, you are a CASP if on a discretionary basis you manage client portfolios that include crypto assets, even if you also manage other assets. And as such, you'll need to ensure that your personnel have the skills, the knowledge, the experience to service clients effectively. The guidelines will likely set out how national regulators should assess that knowledge and experience and those skills. Will they require a minimum number of years of experience, particular qualifications, and indeed will they recognize non-European qualifications for those portfolio management personnel? CASPs also will have a separate obligation to understand their clients by assessing whether particular crypto asset services or particular crypto assets are suitable for those clients. And that's in light of considering the client's experience, knowledge, the client's objectives, and indeed their ability to bear losses. And finally, we can expect guidance on the content of the portfolio statements that a CASP needs to send to clients periodically so that they have a fair view of the portfolio's performance. That needs to be done in a proper way. Okay, moving on to the next slide. There are standards and guidelines that in certain areas that are based not so much on the service provided, but on your status, if I can put it that way. Not so much on the service you provide again, but sort of what you are. So, for example, there's a requirement to have in place systems to monitor and detect market abuse. And by market abuse, we mean things like exploiting inside information, market manipulation, activities that effectively undermine the integrity of the market and move or distort the market, things like front running and wash trades. In the coming months, I suspect the systems and procedures to detect and prevent market abuse, and these things will apply to any person professionally arranging or executing transactions involving crypto assets, will be specified. Separately, guidelines will be adopted so that national regulators adopt and themselves adopt and implement, more importantly, consistent supervisory practices on market abuse across the EU. Specifically for inside information, there will be standards to enable disclosure of that information by CASPs. That's a technical standard. If you're thinking about acquiring a CASP, and you might be, or owning a threshold stake in a CASP, then there are special information disclosures you'll need to make to the national regulator before you acquire that stake. Again, similar to the authorization process that also catches qualifying holders. So we expect to see clarity on whether a self-declaration about your background in order to prove your good repute will be sufficient, things I've already touched upon. And finally, if you're a bank or an e-money institution or one of a number of other EU financial institutions specified in MiCA, then although you won't necessarily need authorization under MiCA, you will need to provide your national regulator with certain types of information, such as information about your IT systems and risk management framework. Okay, I did mention before that there were a couple of guidelines that I get into in some more detail. Let me begin with those two. So reverse solicitation. This is particularly noteworthy. If you are providing services from outside the EU to an EU client, you need to be authorized. You need to have a registered office in the EU. And as we mentioned in webinar 1, you need the mind and management of the CASP to be in the EU. But if you're providing those services because the client found you, so they sought you out, you as a CASP were effectively passive, then that's what's known as reverse solicitation. You didn't solicit the client solicited you, and that's okay. That's permitted, and you don't have to be authorized to provide your services. But what does it mean to be a passive CASP, to have been solicited, in MiCA's terminology, to have been solicited at the exclusive initiative of the client? So I think it's probably easier to answer that question by understanding the things you shouldn't do as a service provider if you want to stay outside of MiCA. One obvious thing you shouldn't do is approach clients directly or indeed advertise or promote yourself in any way in the EU. Also, if similar EU legislation is anything to go by, I'd reckon that the guidelines will probably spell out that you have to be careful, even if your website is in a non-international EU language. So, English and French are probably going to be okay because those are international languages, and English is spoken in Ireland and Malta, so it's still an official EU language. But if you use Hungarian or even a major non-international language like German, you'd need to be careful, because unless there's a substantial Hungarian-speaking or German-speaking community in the country where you're based, the regulator will probably rightly assume that you're targeting potential clients in Germany, Austria, Hungary, and even parts of Western Romania where Hungarian is widely spoken. You also shouldn't send mail shots to people whose email addresses end in, for example, .it for Italy, or .fr for France, or .es for Spain, for, again, I think what are obvious reasons. Something else to think about: have you as a CASP restricted your app so that it cannot be downloaded in EU countries? If you haven't, and EU-based clients can access your services through the app, you're probably on the wrong side of the line, and you need to be authorized by MiCA. So any and all of these things that I've mentioned could mean that there's no true reverse solicitation, and that you really should be authorized under MiCA. Another thing to note, if you were, even if you were genuinely reverse solicited, you as a CASP were reverse solicited about a particular service the client wanted, but you used that opportunity to cross-sell or upsell, then you could also be getting yourself in trouble, because you need to be authorized under MiCA to do that. A couple of other things to watch out for that you might think are helping you to keep within the reverse solicitation exemption, but maybe aren't helping you. A contractual clause that deems whatever initial interaction there was between the CASP and the client as having been initiated, by the client. So even if that interaction was actually more complicated and included overtures by the CASP. So with all of this in mind, and given the trend in the EU is definitely toward interpreting the reverse solicitation exemption narrowly, and we've seen it with recent pronouncements from the EU over MiFID, for example, we'd expect the guidelines to follow in that vein. So, very narrow interpretation. And at least with the EU, there is this exemption. I think for the US, if I'm not mistaken, really, you couldn't approach a US client based in the US, or indeed a US person anywhere. You'd need to be based in the US. Okay, let's move on to the second notable guideline. When is a crypto asset a financial instrument and when is it not? Is it necessarily one or the other? Could it be both? I mean, these are questions that are relevant for everyone, for issuers of EMTs and issuers of ARTs, as well as CASP. It's also kind of a global question, right? I mean, maybe even a bit of a global headache. It goes beyond the EU and beyond MiCA. So if you're in the, and I guess in the US, you're thinking more in terms of a security than a financial instrument. And I think probably under the Howey test, what you'd find is that, you'd be captured. A crypto asset would be captured. In the EU, it's different. They take a principle-based approach. Sorry, they don't take a principle-based approach. The Howey test is a principle-based approach. They define financial instruments right in the legislation, and MiFID specifically, and MiCA expressly states that crypto assets that fall under existing EU financial services legislation should remain under that legislation, so under those EU laws. So MiCA excludes from itself any crypto asset that is also a financial instrument. It deals only with crypto assets that are otherwise unregulated by the EU. So this is where the guidance will come in, I think, and attempt to delineate between financial instruments under MiFID and crypto assets under MiCA. And that's not an easy task when you remember that classifying a crypto asset as a financial instrument under MiFID itself depends on the application of the notion of transferable security by individual EU countries, and that therefore crypto assets could be considered a transferable security in one country and not another. This would seem a ripe area for the guidelines to address. There's a lot more to say and think about here, but I'm going to leave it there for now, and back to you, David.
Thank you, Lloyd. Back to stablecoins. The European Banking Authority will develop standards specifying liquidity requirements for the reserve of assets of an asset reference token issuer. MiCA specifies that issuers of asset reference tokens shall maintain a reserve of assets, and that this reserve is insulated from the issuer's own assets. This means that creditors of the issuer should have no claim on this reserve of assets, particularly in the event of insolvency. This reserve of assets needs to be managed in such a way to address liquidity risks associated with the redemption rights of holders. Simply put, if a significant number of token holders decide to redeem these at the same time, will the issuer be able to meet these requests? This standard will specify how reserves should be structured to handle this, and MiCA is already quite specific about how this should be done. The standard will establish the relevant percentage of reserve of assets to be held according to daily maturities. This is the assets that can be sold or withdrawn with 1 day's notice, typically cash or securities. It will also establish the relevant percentage to be held according to weekly maturities. So this is the assets that can be sold with 5 days notice. When setting these percentages, the EBA will take into account thresholds already set elsewhere, specifically the UCITS directive, the Undertaking for Collective Investment in Transferable Securities. This directive establishes that an investment fund should not invest more than 5% of its assets in transferable securities or money market instruments issued by the same body, for instance, shares or bonds. Investment funds should also not invest more than 20% of its assets in deposits made with the same body. It is likely that we could see similar thresholds for the investment of reserve assets for ART issuers. MiCA has already specified the minimum amounts of each currency referenced that need to be held as deposits in a bank. This cannot be less than 30% of the amount referenced in each currency. So, for example, if an issuer of asset reference tokens make up 100 million euros, they will need to hold at least 30 million on deposit with a bank. Now, something that politicians in the EU have pushed hard for in MiCA is requirements around the publication of environmental and climate-related impact of a crypto asset. The environmental impact of crypto assets has become an increasingly hot topic, primarily because the energy consumption used for proof of work consensus mechanisms, specifically Bitcoin. The consensus mechanism refers to the mechanism that allows crypto assets to function and makes it more difficult for bad actors to commit fraud. This can come in a number of forms, the most common being proof of work and proof of stake. Proof of stake involves pledging or locking up some of your crypto assets. This is to vouch for the accuracy of the newly added information required for a transaction, and this is less energy intensive. Proof of work requires mining, i.e. solving complex cryptographical puzzles before the new information can be added, and this often uses massive amounts of energy. The big energy consumer here is Bitcoin. On the slide, you will see a comparison of the annual electricity consumption per year of Bitcoin, which rivals the likes of entire countries, notably the Netherlands and Argentina. As a consequence of Bitcoin's energy consumption, ART issuers will now be required to include details of the environmental impact of their tokens. In reality, this is a bit of a red herring, since most consensus mechanisms will use proof of stake. Ethereum, one of the last big proof of work consensus mechanism tokens besides Bitcoin, switched in September last year to proof of stake, cutting its electricity consumption by an estimated 99.9%. Now, it's not only crypto that these European legislators are focusing on when it comes to climate-related impact, but Bitcoin, with its high energy consumption, has pushed the crypto industry to the front of this queue. The standard itself will be developed by ESMA in cooperation with the EBA, and it will likely set out the information that needs to be included in a white paper relating to environmental impact, such as annual emissions, and how issuers plan to mitigate this. As you'll know, if you joined us in our last webinar, the text for MiCA has been agreed and is in the process of being translated into all of the official languages of the EU. Delays to this have pushed back the final publication date of MiCA to Q2 this year. Once MiCA is published, the drafting of the guidelines and standards will begin by the European supervisory authorities. As you can see, there are 4 different deadlines depending on the timeline stipulated for each area of guidance or standard in MiCA. The ESAs, the European supervisory authorities, will really have their work cut out within the first 12 months of MiCA coming into force. In this initial period, there are 5 areas for guidelines, 8 areas for implementing technical standards, and 21 areas for regulatory technical standards. This burden is fairly evenly shared between the EBA and ESMA and will be expected before Q2 of next year, which is set to be the implementation date also for issuers of stablecoins. For guidelines issued by ESMA, usually national competent authorities are expected to comply with measures within 2 months of the publication date. Now, if you're listening to this webinar thinking, I have some views on these guidelines, or these are set to affect my business, you still have the opportunity to influence the process. MiCA itself is more or less wrapped up, but the guidelines and standards are only just getting started. The European supervisory authorities, so the EBA, ESMA, the ECB, will likely later this year announce consultations with the public on some of the guidelines or standards that we've been over today. They will decide on which areas to put out to the public for consultation. It isn't clear which areas these will be, but we can get an idea based on consultations they have issued for other financial industries. What is clear is that not all of the required guidelines or standards will first be put out for public consultation. On the right here, you'll see a consultation paper that ESMA put out to industry last year. This was on the forms to apply for permission to operate a DLT market infrastructure under the DLT pilot regime. This is a boring procedural consultation, but I use it as an example because ESMA will likely put out something very similar for MiCA. Past consultations for the financial service industry by ESMA have included the authorization process, transparency of trade data, and governance arrangements. We could also see something on the classification of crypto as financial instruments or on the content of redemption plans. These consultations will be issued across the year, and they're typically open for 2 months. XReg will be monitoring these and looking to prepare responses where relevant, and we'll be keeping clients updated on any consultations. And with that, I'll hand back to Sean.
Well, thank you very much, both of you, David and Lloyd, for your very comprehensive and insightful overviews of what can be expected from MiCA's technical specifications and guidelines. So let me turn now to the questions. We've got quite a few in the Q&A box, and one or two also, I think, in the chat. So let's try and cover as many as we can in the next 10 minutes. We have a question from someone asking if issuers of stablecoins based outside the EU, I'm assuming that means issuers who are based outside the EU, that are then traded on EU exchanges, do they, the issuers, need to comply with MiCA? David, is that one you'd like to come in on?
Yes, sure. So first of all, to issue or offer stablecoins in the EU, you need to comply with MiCA. If your stablecoins are admitted to trading by EU CASPs, then there will be obligations that the CASP needs to comply with as well. So an EU CASP will only be able to admit to trading stablecoins that comply with MiCA. Now, on a similar note, e-money tokens denominated in currencies of the EU, so euro and a few others, also need to comply with MiCA, even if the issuer is outside of the EU.
But presumably the issuer of, say, a US dollar stablecoin that is not offered for trading in the EU, or is not traded in the EU, or is not offered to customers in the EU, that is then where that issuer is outside the EU, they presumably would not be caught by MiCA, but they'd have to keep everything effectively outside the EU. Is that right?
Yes, that would be right. And
of course that cuts out a market of some 450 million people. So I guess it's folks are going to have to consider the business implications of staying entirely away from the European Union. We've also got a question here from someone about who would be responsible for compliance with these standards in the case of decentralized CASP. So I think it's probably important to clarify here that compliance is with MiCA itself, or potentially with some of the other legislative acts that will become applicable to, for example, CASPs, rather than separately to the standards. So the standards go some way to enrich or enhance things that are not sufficiently detailed inside the regulation itself. And the whole question of decentralized crypto, the whole issue of DeFi, is one that very much sits at the moment outside MiCA. So we need then to consider, well, what is DeFi? Is there an absolutely clear and adequate definition of what keeps you in MiCA if you call yourself DeFi or outside? And this is definitely a continuing grey area, and it's one of the reasons that I think there is an ongoing piece of work. I think we saw it on your timeline there, David, that will help to clarify over time. Maybe that's something that is not part of the legislation, though, until maybe MiCA 2, whenever that is. And my own view on that is it's unlikely to be in under 5 years. So DeFi is going to be difficult, but I think one thing that we can say is just labeling something as DeFi, as decentralized, isn't going to make it so. There's an acronym, DNODE, DeFi in name only. I think simplistically, you could consider that something that is capable of, which is capable of being regulated, in other words, where you can hold someone accountable, is likely to fall in scope, and where there is no one to hold accountable, or where it's not possible to identify and hold someone accountable, there's likely to be DeFi. But that's far too simplistic an approach, I know, and this will be the subject of much debate and consideration, and probably case law, not only in Europe, but in many jurisdictions that are still grappling with the notion of decentralized finance. We have a question, Lloyd, from someone asking about passporting. So this is where you can be licensed in one EU member state and apply that authorization to allow you to operate throughout the rest of the European Union. That's something that you find in applicable in MiFID, that applies to investment firms, for example, and there are other financial services where one can passport one's authorization across into other EU member states. But the question that we're being asked here is that the regulation in the EU for crypto is going to become extremely prescriptive and arguably restrictive. So do we think, sorry, I'm looking at the wrong question here. Forgive me. The question here about passporting is whether one will be able to transfer or use one's authorization in one country in Europe with another. David, would you like to tackle that one?
Yes, so once licensed in the EU under MiCA, firms would be able to passport, and that means that they could offer their services to any other country in the European Union. Now, they would still have to comply with anti-money laundering legislation in each country, but the passporting would apply.
Thanks very much. A lovely question here from which forgive me, I started to read. I was so enthralled by it mistakenly before. But someone's asking the question: do we think MiCA will become the global regulatory standard? Well, it's certainly, in spite of the time that it's taken to be enacted, it is still the case that the European Union is probably the first major economy that has come out with some discrete and specific crypto asset regulations. So I think it's quite likely that it's going to be copied by many other jurisdictions around the world. But there are plenty of others already out there seizing the opportunity to regulate in this crypto space. It'd be very interesting to see how significant those other regimes, sometimes more or less onerous, more tailored, if you like, for crypto, how successful they will be. Regulators will always say that they want to avoid what's known as regulatory arbitrage. And it's going to be interesting to see whether, in fact, many different regimes around the world will be competing one with another. This is going to be a very interesting space. We have a question from someone about derivatives. MiFID classifies derivatives such as futures and options as financial instruments. But when the underlying asset of a derivative is a crypto asset, for example, a Bitcoin future, is this classified as a financial instrument and therefore dealt with under MiFID, or would it be dealt with under MiCA? Lloyd, perhaps you could come in on that one.
Thank you, Sean. So yeah, the basic premise of the question is correct. So that there are defined financial instruments in MiFID, and depending on the characteristics, I mean, if it meets that definition, be it a derivative or anything else, then it will come under MiFID and not under MiCA. But it really does depend upon the very specific details of the derivative, in my view.
And so I suppose if if some particular product, for want of a better expression, meets some particular instrument, meets the definition of a financial instrument in any way, shape or form, then it will be considered a financial instrument, regardless of whether it also would meet the definition of a crypto asset. So a crypto asset that is also a financial instrument, you can look to MiFID, the Markets in Financial Instruments Directive, a very much longer standing piece of European legislation, and largely ignore MiCA. So there's a particular piece of guidance that you heard about today, which aims to clarify how you regard what characteristics would be necessary and how you would then regard a crypto asset as a financial instrument. But if it's a financial instrument, MiFID applies, forget MiCA, would be a simple way of looking at it. The devil, of course, as Lloyd said, is in the detail, and it'll be very interesting to see how that perimeter between financial instrument and a token of some form or another, how that perimeter is straddled. I think we could see some very interesting developments in crypto that tries and addresses that issue. But I suppose if you've got a share in a publicly quoted company, it's quite clearly a financial instrument, and even its tokenized form will be considered a financial instrument. If you've got a futures contract, regardless of what the underlying is, whether that's that same public company's share price or whether it is the price of Bitcoin, doesn't make any difference. It is the derivative that brings it within MiFID, the fact derivative, and therefore it will be treated as a financial instrument. Well
said.
Ladies and gentlemen, my thanks to David and Lloyd for your fantastically insightful explanations today. A reminder to everyone that you can download our updated MiCA Explainer or watch previous MiCA webinars by going to the Insights section of our website. You'll find that at www.xreg.consulting, or alternatively drop us an email at contact@xreg.consulting, or use the inquiry form on our website, or indeed reach out to one of us on LinkedIn. We'll be happy to send you links and copies and hopefully answer your questions. Please remember, if you want, we're going to hang back after the end of this webinar, so feel free to do that. If you have some further questions, there's certainly some more in the chat boxes. You can subscribe on the website to be notified about our next MiCA webinars, when we'll certainly be explaining more about the other legislation, such as DORA, with which token issuers and CASPs will need to comply in Europe. And so thank you, everyone, for attending today. Thank you.
Thank you.
And for those of you who'd like to hang back, we'll certainly be happy to take questions. The very efficient Alexandra, who's been made all of this possible. Maybe you can allow folks to use their audio. If anybody has a particular point you'd like to make, a question you'd like to ask, please feel free to raise your hand, and I will do my best to give you the floor, and we'll hang on for a few more minutes in case you have some further questions, or indeed questions you may already have asked that we weren't able to get to, and that you'd like to. We'll try and if you put them to us again, I'll try and make sure we can answer them for you. I know that there were a couple of questions, guys, that have been asked here in the Q&A. There's one here I hope I addressed just at the end there, but been a question about what we're planning to do this year, presumably in relation to the EU, and we're certainly accelerating our efforts to tackle all of these technical standards and guidelines to enable us to keep our clients fully informed. And of course, we'll be spending a lot of time on more webinars over these coming weeks and months that delve into each of them in more detail, and also into other regulations such as DORA that are going to apply to this sector. There's an interesting point here someone's picked up on relating to the crypto asset service providers that have a mobile app, and the app, if the app is not available to clients in the EU, then how can EU citizens choose out of their own initiative to reach out? I mean, it's a very good question, and the problem is we don't know what the guidelines and standards are going to say yet on this, so it will be something that I think most folks will be interested to understand what will bring them in scope of solicitation, and therefore what might be considered reverse solicitation. So we don't know, to be honest. It's a thought. We do know that the European supervisory agencies are becoming more strict, more robust in their approach to reverse solicitation. So will an app that is intentionally, shall we say, made available in countries within the EU, will that be deemed to be soliciting or not? We certainly think it might be. You heard Lloyd give a number of examples where we thought that could be the case, but I think we will have to see what is in the detail of the technical standards and guidelines. Now we have a hand raised by Lynn. You've been given the floor, so fire away, Lynn, with your question, please.
Hi, can you hear me?
We can indeed. Go ahead.
Okay, thank you. I just popped a question in, which is really if you could give us some more information about how the ITS and RTS consultation process would operate from a practical perspective, both in terms of how the ESAs would conduct them and communicate, and then also what opportunities industry participants will have to engage, provide comments, or be part of the process. I think some of us here may all remember how painful some of the MiFID technical standards ultimately ended up. So I think these consultations will be very, very important for the entire industry. Thank you.
You ask an exceptionally good question, and one that you do well to when you remind us about what happened with MiFID. It is always hoped that these technical standards and guidelines help clarify, but quite often they they just open up more cans of worms, as you might say. So these consultations will definitely be a good way to get information back. Whether or not they then get acted upon is, of course, another question. And I guess we will see the ESAs under a lot of time constraints to get these standards and guidelines out there, especially the technical standards, which will be binding. To get them out there in a timely fashion means, that quite often they'll be quite rushed, and then there'll have to be the process of publishing them, getting the consultation responses, and considering them. But David, you know a bit about this consultation process. I wonder maybe you could put some more color into how one could find out about them, what, based on other consultations, what process tends to be. I think this would probably help Lynn consider it, and others, hopefully.
Yeah, so the consultations are usually put up on the websites of ESMA or the EBA or the ECB, and it's probably best just to kind of to monitor them as they come up. Usually the consultations typically open for around 2 months, so you don't have a great deal of time to respond to these, and you have to be pretty quick off the mark when they come out. But they will be issued likely across the year. I think Sean's already mentioned the ESAs will have their work cut out, especially in the first 12 months, and they will be the ones who decide what goes out for consultation. So there might be an area that you think you'd like to give a lot of input to, and it might not even go out for consultation. It'll be entirely up to the ESAs.
Indeed. So you may. Some of you recall that the new anti-money laundering package, some of which directly interact certainly with things like definitions of crypto asset service providers, and will affect crypto quite significantly. That legislation passed into law ahead of MiCA, and within that, there are guidelines that have to be updated. The EBA, as an example, has been working hard to get ready to publish get ready to draft those guidelines and updates to existing guidelines, new guidelines for crypto, for example, and quite typically, it's looking at timelines that can take up to 6, 9, 12 months forward before the consultation papers are published, the consultation period closes, and then for the ESAs to consider the feedback that's been received and then form a view about it, and so on and so forth. So quite a few of these consultation projects for the ESAs take typically a year. That's nothing unusual. So this is why I think we're concerned that some of the timelines are going to be very challenging for obligations that fall on folks under MiCA itself. I hope that answered your question, Lynn, but feel free to follow up if you have any further.
Just one follow-up question. Thank you for that very useful explanation. I recall that at times individual firms would attempt to continue the dialogue, post the closing of the consultation, with discussions with the individual agency or regulatory body representatives to try and continue to influence the process. I don't know if that will come about in this set of dialogues, but I can imagine that with a tight 2-month time frame, that there will be a lot of firms trying to get their information and preferences expressed. So it will be interesting, just making an observation, it will be interesting to see how these processes proceed, because the 2 months I think is quite tight in my own view.
I think you're absolutely right. I mean, one of the reasons why we keep so close to the ESAs is so that we can try and get insights, if not on the text, at least on the direction of travel before anything is published. And that allows us to feed back to our clients and frame, give them time to frame their responses to that direction, and it helps them when the consultations are eventually published to, if you like, have the thinking done, so they can then interpret the text, and quite often through us ask us to be involved in making representations through the consultation period for them. Sometimes we're able to group some of those responses together where the responses where the feedback is similar across a number of clients, and so on and so forth. So yeah, there's you're right. 2 months is not an awful long time, and yet that 2 months falls within something that could be anything between 9 and 12 months from now.
Mm-hmm. Okay. Well, thank you for that very helpful response.
You're very welcome, Lynn. Edmund, you've asked a question in the chat here about tokenized instruments of some form, tokenized financial instruments, and you're suggesting that the definition of a crypto asset will have to be amended after the DLT pilot regime. Be very interested to hear from you, if you're able, why you think that that definition may need to be changed.
Hi, everyone. Hopefully you can hear me okay.
Yes, we can. Go ahead.
Thank you. This has been a really, really instructive presentation. So thank you for it, and all your team. No, I'm just wondering, the definition of crypto asset seems really broad. So if tokenized financial instruments are going to be subject to the DLT pilot regime once that gets formalized, I'm just wondering whether the crypto asset definition in MiCA will have to be maybe tweaked to potentially exclude the tokenized trading of Tesla, etc., or which I think I understood from what you said would fall under MiFID rather than MiCA. Yes,
well, that's our view. Of course, we wait to, and that's effectively what MiCA says. But Tesla's perhaps not going to be one of those grey area. Tokenized Tesla shares probably not going to be such a challenge. It'll be quite clear, but there certainly could be other instruments that might be more woolly. But I'm not sure why you think the definition would need to be changed, because I suspect that's probably one of the last things we'll see changed within MiCA. Of course, in MiCA 2, we might well see some changes, but I personally, I doubt very much that we'll see any changes in definitions. You have something particular in mind here in the way that it interacts with the DLT pilot regime, a quite separate regime to do with market infrastructure relating to the use of DLT?
Yeah, no, I just thought that the to carve out the tokenized securities more clearly, they might change at the definitional level, but perhaps not when it's read together. I don't have the text in front of me now at the moment, but the definition is very broad, but it sounds like maybe it's more clear than I'm imagining.
Well, I think the helpful thing here is that if there's a kind of order of preference, so if you think of a particular instrument that is both tokenized and something that falls within the definition of a financial instrument, if you tick the box on the definition of financial instrument, whatever type of financial instrument it is going to fall into the MiFID regime and not be considered, to all intents and purposes, not going to be considered within MiCA.
Yeah, that's a really helpful clarification, because just as written here, digital asset means digital representation of value or a right which may be transferred or stored electronically using DLT or similar technology. So on its face, a tokenized security might do that. But as you say, if it ticks the box of being a financial instrument, it falls under MiFID.
Yep.
Really helpful. Another question I might have is maybe more of a open-ended one, but crypto assets are different beasts than financial instruments. And I wonder, do you see practical problems for custodians seeking to verify ownership of crypto assets? You know, that's one of their principal tasks, to book assets and to clearly demark who actually owns them. Maybe this becomes, I don't know if you've seen this come up as a question, or whether off-chain versus on-chain, cold wallet coming out of the ether into a DLT system for the first time to try to verify ownership. Do you see practical issues with that?
Absolutely. I mean, you might be able to determine who controls the asset, but not who owns the asset. There are a number of protocols being played with at the moment that seek to enable a proof of control. A lot of those have been developed largely to satisfy requirements under the so-called travel rule, whether applied internationally or the EU's flavor of that, which again is part of that AML package. And this is the piece of regulation that deals with identifying and verifying the identity of one's customer, passing that information over in a VASP to VASP or CASP to CASP transfer, and similar provisions, due diligence provisions on counterpart VASP and so on and so forth. Within an AML context, you have exactly the same problem, and these problems are currently being discussed. I know for a fact, currently being discussed at various levels within the EU and elsewhere, in order to satisfy those identification requirements, yet alone those that might be needed for trading purposes under MiCA. It's likely to be the case, I imagine, that whatever is sufficient under the travel rule is probably going to be sufficient, will be sufficient for MiCA purposes. But yes, there are some very real and different practical issues, including no less than there isn't a registration system as such. There aren't central registries of ownership of crypto assets, and that's a fundamental difference that perhaps hasn't necessarily been fully grasped by regulators or by policymakers in forming their regulation the world over, actually.
Thank you very much.
Not at all. Well, I think as this brings us close to 20 minutes past the hour, I'd like to thank everyone again. If you stayed behind to listen, thank you. And if you have further questions or would like further information, please do reach out to us. The address is there on the slide on the screen. Thank you again for attending.